Hello, everyone. This is Tom Fox, and I'd like to welcome you to episode 290 of the FCPA Compliance and Ethics Report. The FCPA Compliance and Ethics Report is sponsored by the Red Flag Group. The Red Flag Group is a business advisory, information services, and technological firm that helps corporations, financial institutions, governments, and SMEs to manage their integrity and compliance in their businesses and third parties. You can check out more about the Red Flag Group by looking at their website, www.redflaggroup.com. In today's episode, I visit with Professor Samuel Buell. He is the Bernard Fishman Professor of Law at Duke University and an expert in criminal law. He served as a lead prosecutor for the Department of Justice's Enron Task Force, and he wrote a book entitled Capital Offenses, subtitled Business Crime and Punishment in America's Corporate Age. Kirk Eichenwald has called Capital Offenses a groundbreaking book, one that provides a fascinating analysis of the seemingly endless phenomenon of white-collar crime. It is uniquely positioned to detail the circumstances and complexities surrounding corporate crime. In an era when legal violations in the boardrooms have destroyed and even ended lives, Professor Buell's book is an essential book that explains what every American needs to know about these offenses. It is a really interesting interview. The book is fascinating. I'm going to link to the show notes, and I hope you enjoy it. This is Tom Fox. Thank you very much for listening to this episode of the FCPA Compliance Report. Hello, everyone. This is Tom Fox. I'd like to welcome you to this episode of the FCPA Compliance Report. Today, I have back with me Professor Samuel Buell. He is the author of Capital Offenses, Business Crime and Punishment in America's Corporate Age. Professor, welcome.
Thanks for having me again, Tom.
Yeah, you were on, we had a prior podcast where you talked about an article you penned for Slate Online, and that got me to find out about your book. So I sat down and read it, and I will have to say you've got some great stuff in here. So you were gracious enough to come back and talk to us about the book.
Thanks for having me.
Yeah, so could you start off by telling us why did you write this book?
Well, I was definitely at that stage as an academic when it was time to write a book. I'd been writing journal articles and teaching about corporate crime for about 10 years when I started this project. And, you know, if you go with that old rule that you don't really become an expert on anything until you've done it for 10 years, you know, it was about time to put it all together.
Right.
But then the question was what kind of a book to write. And you know, typically an academic at that stage will write a book for a university press that will be pitched mostly to other academics. And those books are important in what we do, and they move the ball forward as far as knowledge goes, but they tend to be very dense and technical often. And they only reach a limited readership. The discussion that had been ongoing in the United States since the 2008 financial crisis, where the subject of corporate crime had really taken center stage in our public discourse in a way that it had never quite before, convinced me that it'd be both more fun and more useful to write a book for a general audience that was less dense, more breezy, more pitched to non-lawyers. I think it's a book that's accessible to and helpful to lawyers, but it's also a book that anybody can read and understand what's going on. And I felt like, you know, to get an explanation of the complexities of corporate crime would help the general reader who might perceive, you know, as the public discussion has gone, that these issues are far more black and white than they really are. And so it was a challenge to myself of, can I write a book about a complex subject that makes it clear and without, being trite and attempting to suggest that anything has an easy solution. So that's the kind of book I ended up writing, and I had an awful lot of fun writing it. I don't know how wide of a readership it ends up reaching because I'm not sure its message is one that everybody wants to hear. I mean, I think, a lot of people want to hear, these guys just did a bunch of bad stuff, lock them all up. If you've got anything else to say, I'm not interested. There's other people who feel like prosecutors in the criminal law have no business in the corporate sector. they're mucking around in something they should get their hands off of. I mean, if that's your committed view either way, you're probably not going to like my book.
Well, let me stop you there because I have to disagree with you on that point. I think your book answers both of those arguments in a way that both presents the legal underlying legal theories, which I certainly appreciate as a lawyer, but also you take on some pretty broader questions, such as who or what should be punished and who belongs in prison. So, who or what should be punished in this area of the law?
Well, it's difficult often to say, and I want people to appreciate that above all. The line drawing exercise in white collar crime is a very difficult one, and the area that I spend the most time on in the book is the law of fraud, where what we're really trying to do is, when we decide what's criminal fraud, is draw a line between sharp, aggressive, creative business practice and deception and cheating. And those are necessarily fluid concepts. They depend on the evolving norms that control in particular markets, in particular industries, and in particular social moments over time. And the law has to kind of mediate between those evolving norms and the legal rules, which are very broad in this context. I mean, they say don't commit fraud. And after all, if we say that the concept of fraud is really, well, it's deception. It's deception involving some kind of a property interest. You get something from somebody by deceiving them. Well, we deceive each other to get things all the time, and it's particularly in the business world. I mean, it's standard, for example, in negotiation to misrepresent what you're willing to settle for and so forth. So there's a lot, it's not as simple as just saying, well, if you don't tell the truth, you committed fraud. And the book has many, many examples that it goes through that I think are very accessible examples to help people understand that difficulty of that line drawing, from very simple, examples about people, haggling over used cars, to the mortgage-backed securities transactions, and why those were sometimes difficult to say whether there was fraud involved. So that, I think, is a function of the fact that we have this highly entrepreneurial, evolved capitalist economy where we exalt and incentivize with great material incentives creativity. And for the law to police that kind of a system is necessarily going to raise difficult issues about what should be punished. And we're never going to stop having that conversation. It's one of the points in my book. There isn't a way to, because innovation is so ever present and it moves so fast, there's no way to make legal rules that are going to, just make everything clear one day. We're always going to have to be having this conversation about what counts as fraud, or what counts as obstruction of justice, or what counts as misconduct in the environmental or the pharmaceutical context, or even what counts as bribery, to get to the issue that you are particularly concerned of with the FCPA. So that's the what should be punished problem, and then there's also the book deals quite extensively with the who should be punished problem. I don't know
before you get there, let me just say you've got some great analogies and some visual analogies for me, and one of which was Snidely Whiplash, because I grew up with Rocky and Bullwinkle. So you use Snidely properly for the analogy of mustache twirling. So why don't you tell us about how you use that, particularly about the question of who belongs in prison?
Well, we get down, as I think most lawyers who work in this field know well. In the difficult white-collar cases, we always get down to mental state, right? And we say, well, what really separates the civil case or the legal behavior from the illegal or criminal is whether it was done with the wrong intent. But intent doesn't really quite fully capture what we mean by criminal mental state. Because if you say, well, the mental state for fraud is the intent to commit fraud, well, then it just depends on what counts as fraud, which is the issue we've already discussed and be very complicated. So, and of course, there's no ignorance of the law defense for fraud. You don't get to say, well, I didn't commit fraud because I didn't think what I was doing was a crime. So we have to have some way of identifying when an actor is engaged in a kind of activity that crosses the line. And I've written about this in my academic work, and it's also in the book quite a bit. There's this concept of consciousness of wrongdoing that keeps popping up in the law of white collar crime, particularly in the fraud area. That it's the person who knows they're doing something wrong. That's the person we can identify as having that particularly bad intent to defraud. And so I used the story of a student who once said to me in class when we were talking about this, well, it's kind of like we look to see if there's any mustache twirling. It's that snidely whiplash idea, that sort of, while you're doing it, you're twirling the mustache and going, ha, 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 I'm getting away with something here. And I think we look for that kind of evidence in fraud and other kinds of cases because we're concerned that we're not, that we not be over applying the law to people who don't mean to be doing anything wrong. And I think that's a real, as all white collar practitioners know, that's a danger with a lot of white collar crime statutes, is that they are very broad and the crime is occurring often in legitimate contexts where people are involved in normal, natural, commercial activities, and you need some mechanism for determining who's gone across the line.
So you used a phrase that, frankly, I had not heard used before, but it may be more because of my civil law background. But you devoted an entire chapter to the term loopholing. Could you explain what you meant by that and how that works into the concepts you set forth in your book?
Well, there's another form of white-collar crime that comes up over and again in a variety of contexts, whether it's tax offenses. I think we see it in the securities context sometimes. We see it in environmental and other areas where the form of the wrongdoing involves a kind of engineering around legal rules. So here it would be not so much that we have a broad rule like don't commit fraud, but we have some very specific, complex regulatory scheme. And the scheme is essentially being defeated by clever loopholing, by organizing your behavior around the rules. And this is an endemic problem for corporate crime, because as long as there are smart people with smart lawyers and money to spend on them, they're going to come up with clever ways to get around the rules. And law is always going to be kind of one step behind, chasing the behaviors that it's trying to regulate. Now, sometimes we say, well, hey, that's fair game. In the tax context, if you can find a way around the rules that's legitimate, okay. But even in that context, we've had huge fights about what kinds of ways around the rules are not legitimate. And there were, as you may know, a series of prosecutions in the last 10 years involving people engaged in the tax shelter industry at major law and accounting firms who were taking their loopholing over the line in such a way that the government was able to say, look, this isn't legitimately organizing your behavior around the law. This is basically defeating the law purposely by doing something is against what the law requires. So this comes up in the accounting fraud context as well often. So, there have been a couple of cases, including the Ebers WorldCom case, where courts have said, look, just because you had some argument that you were technically complying with the rules of GAAP, generally accepted accounting principles, doesn't mean you weren't committing securities fraud if the reason you were doing it and the effect of it was to massively mislead your shareholders. So this is, I think, an interesting issue for me, and why I devote a chapter to it, because, again, I think it's something that is structural to the nature of business crime, because we live in a complex regulatory state, and we have regulations affecting a class of society that is smart, well-educated, and most importantly, well-resourced. And so we're always going to have this kind of cat and mouse game between regulation and behavior, a cat and mouse game that I find fascinating. I've written a couple of academic journal articles about it. So that's what I mean by loopholing.
So let me next turn to something near and dear to my heart, which you devoted to my utter joy several pages on, and some really, I thought, interesting analysis, which of course is the FCPA. And you detail some of the largest cases, certainly the Siemens case, but then you go into really one of the true cruxes that we've never had a judicial determination on, which is what is quid pro quo with a corrupt purpose for the criminal part of the FCPA. We'll have to leave the civil part out of this discussion. But
Right.
you actually, it almost sounded as if you were articulating that the definition in the statute itself is almost circular. So perhaps you could give us some of your thoughts on corruption, the FCPA, and the definition under the statute.
Well, I think first it's important to distinguish between two kinds of cases. I mean, I think that, a lot of times the behavior in the FCPA context is very clear, right? I mean, somebody delivers a suitcase of cash under the table to a government official to close a contract. This is prototypical bribery that any person on the street would recognize in a heartbeat as wrongful. But there, as you know, are other contexts in which money changes hands in certain ways in certain markets and in certain societies or countries where the line is not so clear between what's part of an ordinary commercial transaction and what consists of something extra. We need to look in the mirror with regard to this as the U.S. because we have to recognize the fact that, we have a campaign finance system that legalizes the at least indirect conveyance of large amounts of money to government officials in the political process. So, my point there is simply that where the lines are between what counts as bribery and what is business as usual, are sometimes perhaps not as clear as we think they are, and they may be subject to, differing contexts as you move around the world. So, the legal issue that comes up in related to that I'm interested in is what this word corruptly means in the FCPA and whether it could be taken, although, as you know, we have very few judicial decisions on the FCPA. Everybody in the field is frustrated with that because there's just not a lot of litigation. Most of these cases are settling. There aren't a lot of cases that talk about what corruptly means, but it has to mean more than just the intent to convey a quid pro quo. Otherwise, the statute would be duplicitous, right? Or no, duplicative is the word. It would have two mens reas in it that mean the same thing, right? Because the statute requires an intent to influence, and that's really the quid pro quo part. So, what's the corruptly part? What is intending to influence corruptly? Well, if we look at what's happened in other areas of white collar crime doctrine that I've mentioned already, like fraud and obstruction of justice, we've often had courts saying that higher level mens rea words like this, corruptly, willfully, mean something like awareness of wrongdoing, knowing that what you're doing is wrongful. And I could see a court potentially interpreting that term that way if it had a case, for example, where somebody was arguing, let's say you have a case where the government says, look, this payment does not fit within the grease payments exception of the FCPA. It was just not that kind of a payment. It was too large, or it wasn't the appropriate sort of payment that part of the statute covers. And you could see the defendant saying, well, be that as it may, I thought that it did. Therefore, I wasn't acting with corrupt intent. And so it's not that my case falls within the grease payments exception. It's that my case fails for lack of mens rea. I could see a case like that arising. It would be very interesting.
It would be, and certainly one of the ongoing critiques in the FCPA commentary is that lack of judicial determination in fleshing out the individual words of the statute. I and others have written about that, but more to the point, I'm not sure we're going to get those decisions, and we're certainly not going to get them unless somebody goes to court. So we may have to leave that discussion open for a second day or another day.
Well, it's possible, just to add one more thought on that, and certainly we could take this up at another time. It's possible that the renewed emphasis in the Yates memo on individual prosecutions is going to push line prosecutors to bring more and more individual cases when they settle FCPA cases with companies. And, the more individual cases that get brought, eventually you're going to get some trials. Not everybody's going to plead.
Right. Well, that certainly could be one of the unintended consequences of the Yates memo. And frankly, I'd love to spend an entire podcast going through that with you, but we'll have to save that one as well.
Okay.
One of the other phrases that you used, and frankly, I just fell in love with, is you called the Department of Justice the nation's law firm. And I'd not heard that before either. Perhaps you insiders, that's something that you all say. But could you explain to us what you meant by the Department of Justice being the nation's law firm?
Well, I don't want to take credit for that. I'm pretty sure I stole it from someone else. Although, like a lot of these phrases that kick around in our heads, we don't always remember or know where they came from. But I think somebody else had that. That I did say in the book that it's been known as that, at least among insiders. Well, the idea is, it is really a law firm in the sense that it's a very, very large law office that has a number of components, right? The DOJ isn't just the criminal division, or it's not just the fraud section doing FCPA cases. As everybody knows, there's environmental crime section, there's antitrust, there's the civil division, the civil rights, and organized crime, and on, right? So this is a multi-purpose collection of lawyers whose job it is to essentially solve and address America's biggest problems when it comes to criminal behavior, whether it's terrorism, international drug trafficking, human trafficking, corporate crime, and on down the list. And there really isn't another institution in our legal system that is available to do that. And I think that a couple things that are great about the way DOJ is structured is it has very little mandatory docket, right? It's not like a DA's office where they have a steady stream of cases coming in from the police department that they just have to deal with one way or another. They get to decide, really as a policy matter, from administration to administration, what should be our priorities? What are the problems that most need our resources? And they are very special resources. There's no other prosecutor's office in the country that has the kind of resources that the DOJ has. The other thing that's very, I think, helpful about DOJ is that, as a law firm, it's a national law firm. It's got a law office in every state, at least one, and often several, depending on how many districts there are in that state. So this kind of decentralized structure where the boss of each one of those offices is him or herself a presidential appointee and has a great deal of independence and authority, allows the DOJ to be entrepreneurial. So, if they're a law firm, they're more like a plaintiff's shop than a defense shop, although they do both kinds of work. And I think, this is something that if you go to other countries and you talk to them about their institutions of prosecution, they're both puzzled by our system in the sense that there's so much prosecutorial discretion and they don't really understand how that works. But they're also envious of it because they realize that the tools we have to deal with some of the problems that are affecting people all over the world are actually unique.
So one of the, in addition to simply laying out the legal problems and the practical, political, and factual problems in these types of cases, you actually move forward and suggest some solutions. And I, for one, would encourage you to take your final chapter and maybe expand that into an entire book. But you've got a subchapter entitled America and Its Corporations, the Responsibility Deficit. And in that, you start to lay out some changes which you think, or at least put forward, that we could put in place to help deal with some of the either lack of prosecutions or oversteppings or uses of loopholing by corporations. And I'd like to particularly draw to one phrase that really struck me, which was, you said we could make that matter of fact a matter of law. So with that somewhat long-winded introduction, maybe you could tell us about the responsibility deficit and at least that solution you put forward.
Well, I think, there's a reason why you're saying, gee, this last bit of the book seems like it could be its own book, because, it is the part that looks beyond this book and forward, but it's also it's the part of the book that is the least, frankly, well well formed and crisp, because those solutions are very, very hard, and I haven't thought enough about them, and so maybe that will be the next book, but only after, a lot more work. So the question is, if we look beyond the criminal justice system, where do we look? And I start with the idea that, look, big picture, I think it's quite possible to say. I mean, we never know. We always say we're at these huge historical moments, and you never really know, right, at the time what it's going to look like in retrospect. But it seems that there's at least a case to be made after this last 20 years of, trouble with large corporate failures.
Corporate scandals, certainly. I'm a Houstonian, so Enron is still on the tip of our tongues.
Right. So it's possible, I think, to say that, look, this phenomenon of the very large corporation in America is something that needs a hard new look. Maybe the kind of look it hasn't gotten since the turn of the last century, when we, first were dealing with the very large corporation and its problems. It obviously produced enormous wealth, but also there were many externalities. And we came up with a new regulatory framework, a new way of thinking about corporations to deal with that, which included things like antitrust law and eventually securities regulation. These were fundamental changes in the relationship between government and corporations, and therefore between the people and corporations. And maybe it's that kind of a thinking that we really need now. Maybe we need to look at things like, how are we going to approach firm size, scale? Have we gotten to the point where these large corporations are so complex and so sprawling that it's just unrealistic to think that individual humans are going to be able to effectively manage them? So when we continually pull our hair out about what happens at BP or GM or most recently Wells Fargo, we're seeing the same thing over and over again. And the CEO gets pulled up in front of Congress and gets screamed and yelled at. Why didn't you stop this? Why didn't you fix this sooner? How could you have allowed this to happen? But at a certain point, if it's happening over and over again, we should be thinking, maybe there's something about the institution that we could change, that would change incentives. And another thing we could look at is the basic rules of corporate governance, which have largely been, a function historically of Delaware law, as most people know, because Delaware has won the market for incorporation, and it's won it by having a reasonably balanced body of law, but a body of law that is attractive to corporations. And at various points in our history, we've talked about federalizing corporate law. And it seems in this day and age, to me, unclear why the basic ground rules for the responsibility of corporate management would be the business of a particular state, whatever state, small or large, rather than an issue of national interest that would be handled at the federal level. So these are some of the issues that I would like to explore in greater depth. They're really issues that have to do with the theory of the corporation itself and corporate law and corporate regulation, not criminal law. But I have been an expert in criminal law. The main purpose of this book was to share my knowledge about criminal law and to explain the criminal justice system. And it's at the end of the book that I'm really almost gesturing myself forward into other work.
Well, and the other kind of overlying theme that I got in reading this book, you talked about the entrepreneurial spirit of not only the United States, its people and its corporations, but also law encouraging it. You also talked about, and I thought made pretty clear, that the regulatory system put in place, beginning with the Sherman Antitrust Act through the Wilson administration and their efforts up to the New Deal, and certainly the Securities Act of 33 and 34, put a framework in that gave greater transparency, and really with the entrepreneurial spirit tied with the transparency, at least you postulated that led the United States to have one of its largest explosions of growth, certainly in the corporate arena. And that's something that we don't want to negate too much, but in the current, certainly at least the last 20 years, perhaps some sort of reassessment might be in order.
Well,
Go ahead.
It's I think a question that has been raised by a number of academics recently. There's some literature on this in recent years. Is the fundamental one of the fundamental principles of corporate regulation has been transparency. But the question is, have we reached a point of complexity where transparency doesn't solve the problem anymore? Because you can see, but you can't understand, right? And if you can see, but you can't understand, then what's the value of seeing?
Right.
And that obviously raises a whole bunch of issues about the expert intermediaries in the system who we really rely on to consume the information that's made transparent and to explain it to us. And what are their incentives? Do we need to regulate them more effectively or change the framework around intermediaries, whether they be the accountants, the rating agencies, the lawyers, and so on? So that's definitely one set of questions. But another set of questions is whether, and I think we have moved a step in this direction after the financial crisis with something like the new Consumer Protection Agency in the federal government, is thinking about whether, we do need to take a more of a kind of product regulation approach to the financial sector, which generally, was not the theory behind securities regulation in the first instance. The theory there was just mandate disclosure and make fraud a crime, and not get into the business of whether people ought to be allowed to get into certain products or not. Whereas in areas like pharma and some other food, we do regulate quality. And maybe we need to do more quality regulation in other areas. But again, these are issues that I speak tentatively of because they're not the main thrust of the book, and I'm an academic and a lawyer, which makes me doubly careful, and I want to think a lot more about this.
Well, I, for one, certainly hope you will continue thinking, continue the conversation. I've been visiting with Professor Samuel Buell, the author of Capital Offenses, Business Crime and Punishment in America's Corporate Age. Professor, thanks so much for taking the time to visit with me.
Thank you very much, Tom. It was good to talk to you again.